In this presentation, I want to talk about responsibility and retribution gaps as they apply to the problem of autonomous artificial agents. Specifically, I want to look at how considering non-Eurocentric legal paradigms can help us resolve or gain a further insight into the retribution gap in particular. So first, what are the responsibility and retribution gaps? So consider an accident involving an autonomous vehicle. One question that arises is who should be held responsible for this accident? Should it be the user of the vehicle? Should it be the designer of the vehicle? Should it be someone else? Should it be perhaps no one at all? Secondly, there might be certain types of harms that autonomous agents cause that might rise to the level of crime. And then since crimes require punishment, question arises as to who should be punished for actions carried out by autonomous artificial agents. Again, should it be the people who built the agent, people who are using it, or perhaps the agents themselves? It's unclear, hence the gap. Solutions to these problems are many, but the authors writing about them primarily seek inspiration either in Anglo-American common law or the European civil law and the concepts that we can find therein. And I think that while it's not necessarily a mistake, there is a certain view of crime that underlies these traditions that might narrow down the possibilities for resolving the retribution gap. What I have in mind is this. According to a very popular view, common sense view of crime, certain serious harms to third parties, for instance, death or bodily injury, should generally be considered crimes. That is to say, they should be generally considered offenses against the state. Crimes require punishment, and punishments require the frustration of the interests of the punished party. And that requires that the punished party is capable of suffering. Since autonomous artificial agents are incapable of suffering, it's unclear to what extent the concept of punishment can apply to them. This was best put by Robert Sparrow in his article Killer Robots, where he says that in order for a machine to be capable of being punished, it must be possible for it to be said to suffer. Moreover, its suffering must be of the sort that we find morally compelling, the same sort of suffering that we would find morally compelling in human beings. Since, again, machines, for the foreseeable future, autonomous agents, machines, are not going to be able to have that sort of capacity for that sort of genuine suffering, the gap persists. Now, how can an appeal to a non-Western legal tradition help? In this presentation, I'm going to focus on one example of the legal traditions of the Gitxsan people, who are an indigenous people in Canada's province of British Columbia. And I will rely on work by Valerie Napoleon about the legal traditions of the Gitxsan. In particular, what's most relevant to my purposes here are the two principles of the Gitxsan legal theory that Napoleon mentions in her book. First, it's a focus on compensation rather than determination about guilt. And second is the collectivity rather than individualism insofar as responsibility and compensation are concerned. And it's important to add that the Gitxsan used these traditions, used these principles to handle even the most serious of offenses, including those offenses involving homicide. If we apply this to the topic in hand, we'll see that when it comes to machine crime, we should focus on compensation rather than punishment. Victims of robot crimes should be compensated, we should do that rather than focusing on punishing robots. So one worry about this problem is obviously that robots hold no assets. How can we assign compensation if the offender has no assets to speak of? Well, a response to this, again, comes from the Gibson tradition. A response is something like vicarious liability. In some cases that Napoleon describes in her book, people other than the offending party could furnish compensation for wrongdoing. So we have a person committing some sort of harm, but in virtue of that person's relationship with a group of other people, it might be the responsibility of the other people to issue compensation to the victim of the harm, or people related to the victim if the harm was death. I see no reason why we should not apply this sort of solution when the offending party is an autonomous agent rather than a person. Could also have a different group of people, different than the autonomous agent, being on the hook for compensating for any harms that the autonomous agent caused, including the harms that normally we would see as rising to the level of criminality. If we apply this Gibson legal order to robot crime, if we reimagine crime as calling for compensation rather than punishment, then we will solve the retribution gap. Because if there's no need for punishment, we no longer need to worry about machine suffering, as Sparrow describes, or human responsiveness to machine suffering, or any of these things. So that's my solution. One might wonder, of course, if this is genuine justice, but it seems to me that it is. It's a system that is workable, that could cover all sorts of disputes, even involving the most serious of harms. It works in contemporary societies. So obviously the Gibson are one example, but similar procedures also are at work in other indigenous tribes. I think the Navajos are the most, the Navajo tribe is the best known example of that sort of approach. It doesn't require us to engage in meaningless punishment or to engage in criminal punishment of someone who did not have the guilty mind. And lastly, it prioritizes the victim rather than focusing on the offender. And I think all in all, this is a better approach to machine crime or robot crime than ones that are derived from the Western legal traditions. Thank you.